Thank you all for joining Catherine Wilson and myself, Louise Riedl from Goldhawk Associates, for our online webinar on the return to work and the new normal. For those of you who haven't met with Catherine, she's a partner and head of employment law at Keebles law firm. Goldhawk Associates have been extremely pleased to have worked with Catherine previously, running breakfast seminars or more recently employment law update webinars. I'm sure a lot of you would have attended the webinars in May and June. Most of you are aware of us, Goldhawk Associates. We operate in a number of recruitment sectors, including human resources, accountancy, public practice, technology, and commercial and business support. As some of you are probably aware, I specialise in human resources recruitment and have recently joined Goldhawk, bringing with me over 20 years recruitment experience, the last 5 being within HR recruitment in London, in Kent and London. Obviously, the last 7 months or so have been particularly challenging for all business leaders, particularly HR professionals. We do hope that the content of this webinar and previous webinars we have held will be of use to you as you have made or will be making further decisions as we move forward and work out what the new normal is. So over the next 30 minutes or so, we're delighted to have Catherine provide us with some professional advice and updates that will support you through effective business continuity as we move forward, including changes in the workplace, update on furlough and post-furlough schemes, IR35 changes, and treatment of vulnerable employees. I've collated questions sent to me by some of our participants today, which I will then put to Catherine at the end of the presentation. If anyone has any questions as a result of what is discussed this morning, please enter them onto the Q&A icon at the bottom of your screen, and I will cover these with Catherine at the end of the session. You should be able to see the PowerPoint slides. These and a recording from today will be available on our linked page for everyone to view who's missed today's session or if you need to go back and check something. So we've got a good agenda ahead of us, and I'm now going to hand over to Catherine.
Thanks, Louise. It's a great pleasure for me to be running this event again. I have to say it seems like an awfully long time since July, and an awful lot has happened. When we run these events, we're slightly concerned, or I am, that we're not going to have enough to talk about, but that never seems to be a problem so far. So, as Louise has said, we're going to focus on changes in the workplace and home working, which continues to be a very hot topic. We're also going to look on the update on the furlough scheme and the introduction of post-furlough schemes, such as the job support scheme. In addition to that, the government have come up with a number of other initiatives, and I'm going to cover those up as well, which is the job retention bonus and an additional inducement, if you like, in relation to apprenticeships. But I'm also going to try and touch on some of the stuff that actually has been rather overlooked, and in particular the changes to the agency worker regulations that took place back in the height of the pandemic, back in April 2020. We're then going to look forward and look a little bit about IR35. We think that this is definitely going to come in. It has, of course, been postponed on 2 separate occasions, but the smart money, as I understand it, is on these changes being implemented in April. If nothing else, it will raise revenue, and clearly that's going to be very important going forward. I'm then going to talk specifically about the treatment of vulnerable employees and changes to the Access to Work scheme. And then, as Louisa said, we'll have time for questions and discussion at the end. So next slide, please. So I think changes to the workplace and home working. I said at the beginning, we're always concerned that there isn't going to be enough content for one of these events. An equal concern is that in between setting the agenda and actually doing the event, there will be some changes. And I think we have already seen a number of changes in relation to home working. I think the key thing is, at the moment, the advice is work at home where you can. It's obviously been different in Scotland, it's different in the other devolved regions. I think the rationale for this is quite obvious. If we look at the recent statistics on COVID spread, 26% are linked into workplace settings. You might ask why, if that's the case, that the 4% that are linked to food and restaurants seemingly are more important, but I couldn't possibly comment on that. I'm just the lawyer. But it does seem likely that this guidance on working from home will, if anything, be strengthened, and particularly in relation to those parts of the country which are already under a local lockdown and different rules applying. So if we're assuming that home working is going to be, if not exclusive, a major part of work life for the foreseeable future, then clearly we need to look at those health and safety obligations. It can't be a question, as I think sometimes is the case, of out of sight, out of mind. So when we started dealing with COVID, government was careful to suggest and to insist that the existing obligations still continued to be relevant, no more so than in this area of health and safety. So there's the obligation to have a safe place of work, and that can be a safe home workplace, and also a safe system of work. So if I'm using certain types of equipment, particularly IT, things of that type, then that obviously has to be fit and safe for purpose. Overriding all of that, we also have what we call the common law duties of care to make sure that reasonably foreseeable accidents are avoided wherever possible. So there is still quite a lot to do, and I think those of you who have attended previous seminars will appreciate and recall that we talked a lot about risk assessments, and it'd be interesting to see how many of you feel that those original risk assessments were in fact effective, and how many of you have actually changed it. I know that we as a business at Keebles have had to change our assessments on several occasions. And then I just wanted to touch on this tax implications, because obviously there are additional costs. The savings we have about not having people in the office are borne largely by our employees in their own homes. And we know that employers are able to reimburse additional household expenses, heating, lighting, etc., through receipts. However, in addition to that, there is also the option to claim specific tax relief on unreceipted expenses. So a sort of a general charge, which can be paid either by the employer or indeed the individuals can claim via their tax return. I think the enthusiasm from an employee perspective is they would rather have it paid tax-free by the employer. But to date, relatively few employers in our experience have taken advantage of this. Perhaps they will do as it becomes apparent that significant pay rises are not likely to be forthcoming, and to improve employee morale, because obviously on the old adage, every little helps. So looking on at the next slide, creating a COVID-19 safe workplace. So as safe as possible for people returning to work, for customers, site visitors, etc. The heart of this is the risk assessment. And we need to look at this in two ways, really. We're looking at risk assessments at home and risk assessments at the office. I should point out that the HSE acknowledged that very small micro businesses are in fact excluded from this, so businesses with less than 5 employees, although it is recommended. The key point about these risk assessments, and we've seen this a lot in terms of queries from clients, is that they are shared and discussed with employees. I think the other key point I would highlight with that is that these are not fixed documents, so they do need to be regularly reviewed, and we need to document that we've reviewed them. We need to be able to document the fact that the information was shared, and particularly a number of school contacts have already had HSE virtual assessments on this. And the other key thing, which again I think is really hard at a very busy time for HR professionals, but we need to ensure that we stick to the knitting. So, for example, I have a number of clients where actually their COVID-19 risk assessments have been absolutely fine, but they've totally forgotten about doing risk assessments, for example, in relation to pregnant staff. So unfortunately, this is another example where we need to try and keep all of the balls juggling at the same time. Again, the managing of customers, visitors and contractors, generally to be discouraged, I think is the view. But obviously where it's essential, then there needs to be a clear record kept. Things such as non-invasive temperature checks seem to have reached a lot of enthusiasm, as have clear rules on face masks, gloves, and indeed, as we look on the next slide, about this whole question of social distancing with markers, etc. I do think as well, there's another point which we're going to come on to later on, which I think is very relevant, is who are we encouraging to return to work? Is it essential staff only? Do we need to implement additional hygiene measures, deep cleans, things of that type? I think the other point I would also make is that in terms of the protection, I said at the beginning that there is no specific legislation dealing with COVID-related employment complaints. However, all the existing legislation continues in full force and effect. And I think the areas where I think as employment lawyers we're particularly focused are on things such as protection from whistleblowing. So somebody who complains that the COVID risk assessment is not adequate, and then perceives that they've been subjected to a detriment, for example, a redundancy. And you can imagine how that could play out. So I think it is incredibly important that we try and keep as many of the employees with us. That may not always be possible, but we do have to be able to demonstrate that we've taken all reasonable steps. So we've listened to concerns and we've tried to address them. Note I say address doesn't necessarily mean agree, but we definitely need to be able to be mindful of specific concerns raised and document this, because I think there will be a number of claims which arise out of this pandemic. Next slide. Specific change is this whole very vexed area about self-isolating. So the government now have effectively pushed the burden onto you as employers. So, for example, if you know someone has been on holiday abroad and that they ought to be self-isolating and they turn up at work, then you're not allowed knowingly to permit them. I think the issue there is knowingly. So it's about knowledge. How much information you have about your workers' absence, particularly holiday destinations, is of course a matter of some conjecture. But I think it is one of those areas which we might almost imagine a situation where people returning from holiday will have a meeting akin to the return from sickness meeting just to tick that particular box. Similarly, the workers must tell their employers that they're self-isolating. And I've seen a number of clients who've amended their holiday leave request forms and online provision just to ask that specific question. Effectively, are you going abroad? If so, where are you going abroad? And then when they come back, they say, right, is it okay or is it not? We could also talk, but we probably haven't got time, for all the issues with outstanding holiday, which the pandemic has definitely caused to surface. And there is an awful lot of holiday which is going to need to be either taken or paid out for the next year. But that would be a separate discussion about how we manage that, but something very much to keep front of mind. The other key thing is that an individual who breaches self-isolation will normally commit a separate criminal offence. We will have to see how this level of prohibitive sanction actually works out. I think the jury is still out on how effective it will be. Key point from an employer's perspective is that we are now fully in the frame in terms of policing these provisions. So next slide, please. So just when employment lawyers thought they have something to do, and I think this man, could call him the nickname, the employer's lawyer's friend, Rishi Sunak, pops up with yet another scheme. So certainly Rishi, you have avoided redundancies in employment law. So next slide. I think he's well known about the furlough scheme and the future. So we're now in the last month of that. Government's paying 60% and employers are paying 20%. We have a number of clients where individuals still remain on furlough on this basis. Equally, we have a number of clients who have effectively commenced or are shortly about to commence some type of redundancy exercise. Other clients, there's no doubt about it, decided to commence redundancy exercises earlier so that they could take advantage of the scheme to subsidise things such as the holiday and indeed the notice pay. But in any event, that's probably coming to an end now, and that will end on the 31st of October. So with some excitement, we see the new job support scheme, which begins on the 1st of November, again initially for 6 months. And the aim of this scheme, as I'm sure you're all very aware, is to support employees working at least 33% of their normal hours and to, I think the jargon is, to preserve viable jobs. I think it's incredibly important for employers, however, to realise that aside from the headlines, this is a very different type of scheme. This is a scheme which is premised on supporting employees working, not like the furlough scheme, which effectively supported employees not to work. The cost of the scheme, therefore, to government is considerably less. I think we're looking at a maximum of 22%. It's also premised on the basis that an employer would prefer a couple of part-time staff to a full-timer. I think many of us may have some issues with how accurate that particular assessment is. I think there's also an issue, which is that how will this work if we are looking at a total lockdown situation? So if I'm running a restaurant or bar in central Scotland today, as of tomorrow, I'm going to have 2 weeks, which I can't open. Let's say that spreads into November. This scheme will not cover that because effectively nobody will be working. So the ability of the scheme to really compensate or protect, I think, has to be in some doubt. So next slide, please. Yeah, we're looking at a scheme which is aimed at small and medium-sized businesses. You will have all seen in the press the number of very large businesses who claimed under furlough, some of whom have paid the money back, some of whom have had a lot of negative press. Key points are seemingly quite simple. You have to have a UK bank account and you have to be running UK PAYE salaries. I think it's important to note this distinction between small and medium and large businesses. So what do we mean by a large business? Well, there's no specific provision for that. If you are a large business, however, and you wish to make a claim, then you will need to undergo a financial assessment. Now, clearly, that is to demonstrate that your turnover has genuinely fallen due to COVID and you're not seeking a free lunch, as it were. I think it's also important for people to realise that when they make claims, unlike under the old furlough scheme, this is a lot more prohibitive. So, for example, you will not be allowed to make capital distributions such as shareholder dividends, shareholder buyback, if you're taking money out of this scheme. And again, I think that level of control over future activities may put a number of employers off. So what does it mean? Well, they'll pay 1/3 of lost pay, but this is not uncapped, so it's currently capped at 697. And the employer has to contribute, again, 1/3 of the lost hours. And when we talk about 1/3, it's basically they've got to work 1/3 of normal hours worked. Query whether or not this will last, however, because they're going to do a review 3 months in to see whether or not this is actually effective. It is a bit more flexible, so we're talking about minimum periods of 7 days, but you can cycle on and off, and you don't have to be on the same pattern each week, which I think clearly must be a benefit. First claim can be made in December 2020. I think it would be fair to say that we will see more detailed guidance and analysis from them. I wouldn't be absolutely surprised, given the way in which the health concerns are developing, if the scheme was not significantly altered, to be honest, before that point. Because I think the difficulty at the moment is if you're looking at a lot of businesses that cannot open at all, then there would be very little take up, and that obviously is not the intention. So moving to the next slide. Before we had job support, we also had what we call the job retention bonus, and there have been some very clear guidance issued in relation to job retention bonus quite recently. And effectively, employers receive £1,000 for each employee brought back from furlough, but it has strings. So you have to be continuously employed until the 31st of January 2020. You have to be paid at least £520 per month. So there has to be a salary of £1,560 having been paid. Aim of this is to avoid people who employ individuals on 0 hours contracts making trivial payments, as it were, and then making a claim for £1,000. So that particular potential scam has been closed. Other key thing is that the employee must have been claimed for specifically under the job retention scheme. Now, some clients were very acute to this and seemed to be aware of it before it happened and have made a point of furloughing practically all of their workforce, albeit for fairly short periods of time. They've obviously been fortunate. There will be other clients who did not take that approach and they will be caught by that. The other key point, and I said that there are a lot of differences between these new schemes and the original furlough scheme. And the key point is that the employee must be not under notice of termination on the 31st of January 2021. So what does that mean? Well, unlike the old furlough scheme, where people could be furloughed but under notice, so with a government contribution, that will not be possible in relation to this claim. So you can't effectively use this £1,000 as part of the cover, if you like, for any redundancy or pay in lieu of notice provisions, which is clearly difficult. You couldn't use it anyway for statutory redundancy, but certainly the notice pay can be used under the furlough scheme and has been by a number of clients. So when are the claims for this? Well, they're between the 15th of February and the 31st of March 2021. I would call that, with everything else that's going on, quite a short timescale. So again, something definitely to note. So next slide, please. Again, another initiative is this question about the Apprentice incentive payments, whereby employers will receive £2,000 for apprentices aged 16 to 24 and £1,500 for apprentices aged 25 and over. Key point about that is to say that this is in addition to the existing £1,000 you can get for setting on an apprentice who's between 16 and 18 currently, and indeed for apprentices under 25, where there are specific rules apply, in particular if they've been in care and or they've got an education healthcare plan. So worth looking at. But certainly for the youngest workers, you can see this could be quite an attractive option. So paid in 2 equal instalments. Latterly, they've got to make it through the first 3 months, and indeed then they've got to make it for a full year. But it's only available for those apprentices who started their contract between the 1st of August and the 31st of January 2021. So very relevant now. Other key points about the apprentice incentive payments are that, again, it's different from apprenticeship levy funds. It's much more wide-ranging. Effectively, you can use this money for anything to support costs. So that can be facilities, uniforms, travel costs. Quite an attractive grant, crucially non-repayable. So a lot of flexibility and definitely worth doing for those clients interested in looking at those apprentices. And this is obviously a good time to do that, given that we're just starting the new effective academic year. So next slide. Thank you. I said also in the introduction that there were a number of changes that came in under the radar, as it were, in relation to employment law in April 2020. And one of the key things is this question about changes to the agency workers regulations. You will recall, those of you who really like reading a lot about employment law, that we had something called a Swedish derogation, which effectively meant that the rules about equality of pay for agency staff were disapplied if the agency worker had a permanent contract with the agency and was paid between assignments. This was called the so-called Swedish derogation. Key point is that this is no longer in place. Again, we look as well about how it works in terms of agency workers and their rights, which again are enshrined in the second point on the slide. And then the third point on the slide is that from April, all businesses needed to provide key information documents. And what was in those documents? Well, you might expect the normal sorts of things such as payments, when they're going to be paid, how much, holiday pay, that type of thing. Interestingly, they've inserted for the first time, I think, in any legislation, a limit on how much information you have to give. I think there is a view that if I give somebody a very long contract, with a bit of luck, they never read it. This is to try and counter that, because the key information document must be a maximum of 2 sides of A4. I think it's important from those of you who are not involved as employment agencies, because I think you need to demonstrate that in fact, and be sure that your suppliers have in fact given this key information document out. Other key point I think to make about the agency workers regulations is that we're now starting to move towards, and I hate to mention it, the B word, Brexit. And obviously one of the issues in the referendum campaign was about taking control of our laws. And the present government's view is that clearly we will comply with laws up and including the date of actually leaving. So nothing changes before Christmas this year. Going forward, however, they would appear to have given themselves a bit more room to manoeuvre. And I think if we were looking, and perhaps in future seminars and webinars we will do, I think we will be looking at those areas which might be subject to change. And it seems to me that the agency workers regulations is pretty much top of the hit list currently, because it is felt as not providing that level of flexibility, which was inherent previously in the agency worker approach. And therefore, I think it's definitely a watch this space. Personally, I think the key information document is a very good idea anyway, and many employers would be would benefit from having a good look at it, because certainly we do notice that employees are very unaware of their rights and don't always receive the information with surprising frequency. So next slide, please. The next point is this question about changes to IR35. And I think I said at the beginning that there have been 2 previous delays to the enforcement of this legislation. The plan is aimed at private sector contractors and will replicate the changes that took place in the public sector. I think there might be all sorts of reasons why this change is perceived as so important by government. I suspect it's largely financial. because as a consequence of the public sector changes, we know there has been an enormous increase in revenue, with public sector organisations almost automatically designating also co-workers in terms of tax terms as employees. What happens in R35 in summary is it effectively transfers the responsibility from the intermediaries to deal with the tax and national insurance to the companies receiving the services. So a lot easier to track what's being paid and indeed to recover the money. So a highly contentious area, it's fair to say, and many of you will already have begun to look at some of the provisions when we thought it was going to come in before. So a couple of things to point out. It's aimed at large employers. So again, just as we saw with the risk assessments, we're beginning to see the development of a slight two-tier approach to which employment law is relevant to which type of organisation, and trying to encourage micro businesses and freeing them from too much regulation. But I think when we look at what is a large business for these purposes, you may be quite surprised. So you're a large business if two of the three apply. So you have turnover of 10.2 million, 50 or more employees, or a balance sheet with 5.1 million. So going to be quite effective. I think the other key points to point out are that if you are wondering whether or not a particular individual is caught by IR35, it's probably instructive to look at, and you are encouraged to look at, the HMRC test. I think it's fair to say that with closer examination, there are a number of issues with that test, but particularly the key point, it seems to be, having tried it with a few worked examples, is that if you tick the box that says that you would allow them to substitute, you automatically seem to be able to get out of this tax liability. I think the problem with that is that if you follow that route through the questionnaire online, and there is a challenge from HMRC, they don't seem to really comply with their own rules. So in terms of the ability to produce a substitute, which is perceived as a key part, if you like, of not being an employee, they will, if you were investigated, they would look to see whether or not you ever had, in fact, produced a substitute, and had that ever been acceptable. And for them, they're taking a far more weighted view across a whole different level of factors, more, in fact, in line with the employment tribunal cases that we've seen, which focus a lot on change of control and ability to provide your own equipment and freedom effectively. And that the substitution point is perceived as a bit of a lawyer's device, because if it never happens, it isn't really relevant. So I think great care needs to be taken with this IR35. It will be interesting to see, assuming it comes in, whether or not it changes the practice. But I think there must be a strong view, which is that a number of individuals will simply give up the ghost, as it were, if there is no attraction about being self-employed. And recent months have probably made that look less attractive anyway. And that at that point, they would go on the payroll formally, because at that point, at least, they would get some of the benefits like pension and the better, clearer holiday, etc. So I think it's a thing to really watch this space. We think at the moment it's highly likely that it will, in fact, apply. So next slide, please. I think the treatment of vulnerable employees has become centre stage in this recent months. And we know that until August, individuals who were identified as particularly at risk were permitted, or indeed compelled almost, to stay at home, irrespective of the type of workplace. And it does seem that even going forward, you have to do everything reasonably practicable to protect the vulnerable, including the additional protection measures. I think there are several questions about that, and I'm going to cover some of those in the questions that have been submitted. But suffice to say, I think there is an obligation across the board, which should include the vulnerable, but query whether or not additional measures are needed. And why I raise that is that, as we've said before, the current law exists in parallel with these new provisions. And an individual who's vulnerable may not, you may find this bizarre, but I think it can often be the case, may not, in fact, be considered as disabled for the purposes of the Equality Act 2010, which would impose a duty to make reasonable adjustments to accommodate them in work. Note the phrase reasonable rather than best, but there's no doubt about it, it is a positive action provision. So a disability, though, is talking about a physical, mental impairment, substantial material impact, long-term and substantial on ability to do normal day-to-day activities, and long-term is 12 months or more. We've seen quite a lot of dispute about whether individuals, particularly on the mental health side, have in fact got a disability. So if somebody has become very depressed whilst they've been on furlough or working from home, then by its nature, it will not hit that 12 months. And finding a diagnosis which suggests that it is likely to last has proved to be very difficult. So it very much is a sort of a watch this space. Again, heightened risk assessments, I think, are pretty standard. Things client had an asthmatic member of staff, the clean was not adequate. The clean was not adequate for any member of staff, never mind the asthmatic member of staff. Unfortunately, she was the one who had to be hospitalised following an incident. That was a very poor example of compliance. So I think if you're doing it right for all of the people, generally speaking, you were probably doing it okay in terms of this vulnerable group. There is, however, this underlying issue about the extent to which that they can be expected and permitted to work from home, which is obviously ideal, but not always possible, and also whether or not they can be moved into different roles. But that does depend a bit on how much flexibility you have within your workplace. And clearly at the moment, when we're looking at fairly wholesale redundancies and more being done with less, that again makes it very difficult to accommodate them. Next slide, please. So finally, and this really ties in with the disability provision, the Access to Work scheme that many of you will know has been around for a long time, brought in roughly in about 1995, and it was specifically designed to help those who are disabled, suffering from various health conditions, and giving them, as they say, access to work. In August, the government agreed that they would actually extend this scheme, which is quite generous. I mean, you can get a grant of up to £60,000, and they will fast track grant funding. And in particular, they would always also be a bit more specifically generous, if you like, or practical about the things that can be provided. So I've highlighted some of those on the slide. So can be assisting, providing specialist advice, helping individuals to keep jobs accessible. So if they're not able to take public transport due to COVID and fears about their health and safety, then it can cover the taxi fares, and it can also pay for special equipment, which may, of course, enable individuals to remain at working from home without any extra cost. So those are my sort of update for the few months that have intervened since we were last all together. I'm now going to turn over to the questions and back to Louise.
Brilliant. Thank you, Catherine. Some really interesting content there. So you mentioned about the questions with regards to vulnerable people. So the first question is, what are the obligations for those employees who are in the previously vulnerable or extremely vulnerable categories, where the advice talks about giving them the safest available on-site roles or an alternative role or working pattern? How far do these obligations stretch, and to what extent do we have to comply with this? I.e., should we have to swap people around in job roles? And also, how should we identify these groups?
Yeah, I mean, I think if we deal with the first question, obviously there are no strict legal expectations, supposedly at the moment, for additional controls of those in high-risk groups. As I've just said, if they have a disability, then we have an ongoing higher obligation to them anyway. And I do feel that the existing controls, such as good social distancing, good hygiene, cleaning, ventilation, supervision, should suffice. However, it is a question about how do we support these particular individuals if we can't allow them to work, for example, from home. And it seems to me that there is, a number of ways of doing that, and the communication is absolutely pivotal. However, I think we have to acknowledge that there will be some individuals who cannot actually come back into the office, though thankfully they are pretty rare. Very important, though, that we reflect how we're going to deal with these people, why we've taken the decisions we do in relation to looking at the risk assessments and doing whatever is reasonably practical. I think consultation is pretty much the watchword. Another group as well, which isn't specifically in the question but also needs to be reflected, are those workers who are living with someone who's clinically extremely vulnerable. Now, the extent to comply with this, so for example, your suggestion was, well, we could swap people around. In an ideal world, we would be able to swap people around. However, again, other staff also have their rights. And I think there is a bit of a misnomer, which is that the rights of this particular vulnerable group automatically trump, if you like, the rights of the other individual members of staff. So with consent, you can achieve everything. With fairly broad-based job descriptions, job roles, contracts, you can achieve a lot. Most clients do not operate in that environment. And I think there is a significant risk that if you try and enforce a job swap to accommodate somebody who's extra vulnerable, then you're likely to find yourself at the edge of a complaint from the other member of staff. Some staff are very amenable and will certainly agree on a temporary basis. However, other staff are not. So I think that seems superficially attractive. Start point is always look at the contract. What flexibility have we got? Do we have the magic words which say you can do something else which is broadly equivalent or within the scope of your expertise and experience? But often contracts are not. So it has to be a question of consent. And I am very nervous about this idea that we can swap people like widgets rather interchangeably. Now, identifying the groups again is difficult. It's obviously much more straightforward when we look at, I think we will see more people going back to using a health questionnaire after employment, so at the start of employment. And certainly in terms of existing staff, I think the way in which several clients have tried to address this has been via a in-employment questionnaire under the guise really of health and safety and first aid. So we need to understand whether somebody, for example, has diabetes. Is that diabetes controlled by insulin? Is it medication controlled? Just so that if there is an issue with that individual, we're aware of the position. I think obviously you have the age, so you can do your own age profile if we think that older men are more at risk. And similarly, you would have the information in terms of their BAME background if that was applicable. Very nervous, I have to say, about asking people about their high body mass index. I suspect most people would rather not know and probably don't know. And I just think that could be perceived as quite intrusive. We know at the moment that weight is not in itself a disability, and excess weight is certainly not a protected characteristic under the Equality Act. So theoretically, you can discriminate because somebody's fat. I think that could be very hard work. And in any event, we've still got that obligation to create a reasonably secure our duties of trust and confidence with those employees. So again, I would steer off the weight, but I certainly think you could deal with some of the other queries in a questionnaire. Now, clearly, if somebody refuses to complete that questionnaire, then there is a limit. But I think you would say that you'd discharged your reasonable duty towards them. And that would make it very difficult if there was then a subsequent claim on the basis that you had somehow caused or contributed to in COVID or indeed any other related illness.
Okay, brilliant. Thank you, Catherine. Another question. We operate a high dependency care home. How would you advise we manage the situation with one of our nurses and a home manager, both of whom were previously shielding, and occupational health has advised they cannot work during a COVID outbreak in the home? Can the individual ignore that advice and still choose to work? And are we liable? If they don't work, is it sickness and company sick pay or just SSP? And if we're unable to find alternative work for them, would it be a suspension on full pay, as it suggests in the advice we would have to do for expectant mothers?
Yeah. I mean, the start point is, the individuals are not slaves. So it seems to me that if an individual ignores the advice and chooses to work, then to some extent they're taking that on their own risk. However, I think we are potentially still liable if they could show that we were actually negligent in some way, either through our own actions or those of our employees that we're vicariously liable for, and that in terms of causation, this negligence caused or contributed to the employee contacting, for example, the COVID-19 thing. I suspect and that's probably an issue, because an employee with mild symptoms, pretty unlikely, it seems to me, to bring a claim. Claims are likely to come with the vulnerable employee of the type that you have identified. So clearly there is a potential risk. I think that there is a problem in terms of instructing that individual to remain at home, because at the moment, if they're being told to shield by government, they're not eligible for the statutory sick pay. they would be eligible for the statutory sick pay if they themselves are sick or otherwise unwell. So there's going to be quite an incentive to work if I'm not going to be paid. Now, the suspension on full pay is different because a pregnant mother who is unable to work has always been eligible for what we call medical suspension during their pregnancy. Thankfully, very rare, but it effectively means that they get full pay until their official pregnancy maternity leave kicks in. So there's nothing statutory to say that that applies in this situation here. And again, I think will be quite difficult to use. So, I mean, obviously the best solution for the employee is that you suspend on full pay. I query how long that is likely to be effective and indeed acceptable, given that we could be looking at the thick end of another 12 months, which is a heck of a long time. Company sick pay, I've seen certain clients use to place clinically vulnerable employees, so they're not subject to any of the SSP rules. I think there are issues with that. You'd obviously need medical evidence to confirm this inability to return. And again, it's obviously quite costly. There is also this question about suspension on full pay, a sort of quasi-garden leave, really, so that they're not working. But again, very, very difficult to assess when it would be safe for those individuals to return. So for most individuals and most businesses, I think the options are really a sort of a potpourri, as it were, of different options. So, for example, allowing them to take some annual leave and indeed allowing them to remain on the books but taking unpaid leave, or let's say some reduced amount. But it is a very problematic situation, very difficult to agree with an employee who may feel that the best way of protecting themselves is in fact to be at work, because at least economically they're in a better place. So it is a very tricky situation. I think it would be very harsh to move straight towards some type of capability related dismissal. But you could imagine a situation 2-3 months down the track where, in ordinary circumstances, if somebody's not fit to return to work for the foreseeable future, we would be looking at a termination on the grounds of ill health. And I suspect that we will probably see some of those causes of action, if you like, beginning to apply here if this does not resolve itself quickly. But I think at the moment, to move straight into a sort of capability procedure, I think would be very dangerous.
Thank you. Okay, and then a couple of other questions from today. Is there guidance on how employees pay the working from home entitlement to their employees? I've looked online, but it only shows how the employee can claim it, and the employer is not readily available even from gov.uk.
I can't think of any specific guidance. My understanding is that there is a clear exception. So it's the £6 per week, isn't it? And it's for the periods of time. And I can think of clients who have simply added it to the pay slip, if you like, just as a fixed period of time. So if people had to work from home for 3 months, they made them a lump sum payment after that 3 months, or on the basis of £6 for each of the weeks. So it works out at about 75 quid there or thereabouts. So it's not a fortune. I have had other clients, though, who have thrown it all back on the employee and said, well, you can claim it back yourself. Query how effective that is. Not particularly helpful. I think probably worth talking to your payroll provider if you've got it outsourced, or indeed your accountants, because I think the Institute of Chartered Accountants have actually put out quite a lot of specific guidance for accountants about how they should be advising their clients. So that might be worth another avenue to look at.
Brilliant, thank you. And one final question, unless anyone's got any more they want to put up. How often would you recommend reviewing the COVID risk assessments?
That is quite a difficult question. I think we know that schools are reviewing the COVID risk assessments depending on the number of children and staff who go off with COVID very regularly indeed. So I'm a chair of governance of a school in Bradford and we review it every week. I can't think of any of my employer clients who've done anything like that. I think most people have diarised it on a sort of quarterly basis, but then if they had an actual, so it's a quarterly basis on a rolling situation, but if there's been an actual case, we've then reviewed it specifically in the light of that case, because I think there's nothing like having a bubble go down, as it were, to really make you look at it even more carefully and was there anything we could do. So I think so long as you're reviewing it, pretty regularly, I would say quarterly, and when circumstances change so that you get a case, I would think that would be reasonable. I don't think most of my clients would have the resource or the time to review it much more frequently than that, because a lot of time was spent setting the thing up in the first place.
Lovely. Thank you, Catherine. I don't think we've got any more questions at this stage, so I think we're drawing to a close, unless anyone wants to quickly put some more questions up there. Catherine has said if anyone thinks of any questions they want to ask afterwards or need anything clarified, if you want to email me, then I can then forward it on to Catherine. And remember, this will be put on our LinkedIn page, recording the webinar on the slides, so for people to go back and view. I'm sure everyone will join me in thanking Catherine, some really useful and interesting content, and thank you to all of you for joining us too. Hope you found it useful and look forward to working with you in the future, and please do get in touch if we can help you at all. Thank you.
Thank you very much.